All right, can you run a canine in a driveway if the guy pulled into his driveway during a traffic stop? Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue Gold Law Enforcement Training. Bringing the Roadside Chat, broadcasting from McKinney, Texas. Got a class tomorrow, really looking forward to it. But guys, I have been vindicated. I have been teaching officers that I believed post Collins v. Virginia that it was still permissible to, take a traffic stop to a guy's driveway, right? So if the person is just down the street, from their house, you light them up and they float all right into their driveway, onto their driveway, and you make contact with them. And the question sometimes comes up, all right, what about the dog and so forth? I have been teaching you that I believed that this would be a good example of implied consent, that's where they wanted to take the traffic stop, and you can basically handle business as normal, okay? And I have been vindicated. State versus Hernandez, Arizona, 2018. I have not seen this case before that, but it actually just came to my attention, and the citation is 417 Pacific 3rd P3D. That's, you ever seen that P3D? That's Pacific 207. Basically, what happened here is the officer tried to light up Hernandez for a traffic violation, and just like I said, he floated onto his driveway and stopped, and the cop made contact. They believed that he had marijuana in his vehicle. They did a free air sniff. The dog alerted. They then searched the vehicle, and they charged him accordingly. The Arizona Supreme Court, which does have a history. The Arizona courts have a little bit of a history of going a little extreme on some stuff, but they did say, look, this was basically implied consent. The cops are lawfully present. This did not violate the Fourth Amendment. It did not violate the Arizona State Constitution. Now, one little hiccup here, okay? And this was not addressed by the court directly, but I do have a little fair warning for you. What happens when, not if, it's going to, it has happened before, but what happens when the suspect says, oh, get off my property, right? You don't have a right to be here. Now, obviously, you don't have implied consent anymore. So what do? Now you got to switch from consent to a recognized exception. And all recognized exceptions dealing with curtilage or the home is going to be based on some form of urgency. I do not believe that the driver telling you to get out means that you have to immediately leave. I believe you can assess the situation. A lot of times these drivers will be intoxicated. So if you reasonably believe that the person's intoxicated, we don't want them to go back in their home and escape arrest. We want to take them in custody. I also believe that you can, just arrest them on site probably and take them with you if you have an arrestable offense. In many states where you don't arrest on traffic violations, they still allow you to arrest when they refuse to identify, when they will not sign a citation, when you have reason to believe they will not comply with the the summons and so forth. So that would be a good reason to arrest in this situation. But regardless, I just want you to start thinking about that. I think that a lot of people play my videos during roll call. So for every one view, there's probably at least 20 eyes on these things. Oftentimes, I'm just, kind of with my estimate, but a lot of people see these videos, and that means this is a good time. If you're watching this during roll call or you're watching this to some kind of squad briefing, why don't you guys, after you're done watching this video, start asking yourself, hey, what are we going to do if this person does tell us to leave? Well, I would not run that dog. I don't think you have the authority for that. I think you need PC for that. But, PC to get a warrant. I mean, not just PC to run the dog. I think you just start, hey, we're not going to just leave. We're going to assess the situation. Can we make this arrest based on the traffic violation? Those are the type of, muscle memory things that, I want you to have that kind of scripted so that when it happens, your people are prepared to act constitutionally. All right? Now, I will tell you just one more thing. Some people are watching this like, Anthony, I don't understand this. Why do we have to leave at all, right? Well, as I said, the word is curtilage, and that means that an area around the home that's treated like the home itself. I do believe, and what we teach here at Blue to Gold is that a lot of times these single family homes that have a small driveway or carport, that is going to be treated as curtilage. I believe that most courts that are genuine in their assessment about what the Supreme Court considers curtilage and what it does not, are going to say, yes, this is curtilage, that area right next to the home. I'm not saying a long farm driveway, right? A rural driveway that's 100 feet to the main county road, that may not all be curtilage. It most likely is not. But at the end of the day, that area right next to the home is likely curtilage. So just kind of mind your P's and Q's. All right. If you like what we're doing here, the kind of conversations we're starting, please share with your friends. Hit the like button, leave a comment below. Hey, Anthony, I disagree with you. Anthony, I agree with you. Or maybe a little, follow question and so forth so that I can answer it. Fellow viewers can answer it, so forth. That just tells YouTube, hey, you know what? This guy has good videos. Show it to other like-minded people. Okay? Until next time, my friends, stay safe and please make good case law.